and ready to go. If you'd like to raise your right hand, we'll swear you in. You swear that you will tell the whole truth, you will tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Would you like to start with some remarks?
Yes, thank you, Senator. Good afternoon, Senators. Again, my name is Jim Losty. I represent RBC Capital Markets. I've been in the municipal bond business. It will be 30 years in January, so I've spent my entire career in the municipal bond industry. I have prepared some remarks to start off the hearing this afternoon. Bear with me because they're somewhat lengthy, but I think they will maybe answer some of the questions you have, but possibly serve as a source for other questions. So it'll take a few minutes. Mr. Chairman, Senator Blake, and members of the committee, I want to thank you for the invitation to testify at today's hearing on behalf of RBC Capital Markets. We appreciate the opportunity to put into proper context the role that our firm played in connection with the Harrisburg Authority's financings of the retrofit project and to address some of the egregious errors in the forensic investigation report by Claire Harrison. Let me be clear at the outset that the Harrisburg Authority's problems with the retrofit are not related to the 2003 financings. The financings that we were involved with all performed well, actually exceeding expectations projected at the time of financing, and have saved the Harrisburg Authority money. RBC's capital markets involvement in the financing of the retrofit of the resource recovery facility began in 2003. We served as book-running underwriter for 2 bond issues for the facility that occurred during 2003, the first in May and the second in December. The role of the underwriter in public finance transactions is to sell the issuer's bonds in the market and deliver bond proceeds at settlement. RBC Capital Markets do not serve the Harrisburg Authority, the City of Harrisburg, or Dauphin County as financial advisor for these financings. RBC Capital Markets' parent company, Royal Bank of Canada, also served as counterparty on interest rate swaps and a cap associated with one of the bond offerings, the Series D of 2003. RBC Capital Markets' involvement was limited to the 2003 financings, and we played no role in either the CIT financing or the 2007 financing. As others have previously testified, the forensic audit report contains many inaccuracies. We note that RBC Capital Markets was never contacted during the preparation of this report, which easily could have remedied some of its more obvious errors. In February 2012, shortly after the release of the report, RBC Capital Markets sent a lengthy letter to the receiver and to the Harrisburg Authority members highlighting many of the report's inaccuracies and offering to meet to discuss the report. No response was ever received. This committee has received a copy of that letter. RBC Capital Markets' involvement with the retrofit project started in early 2003, long after the city and the authority had already engaged Barlow Projects as project engineer in 1999. RBC Capital Markets had no role in the selection of Barlow, nor would any underwriter in a typical public financing be involved in the selection of engineers and contractors. The team of finance professionals assembled to work on the retrofit financing was drawn from among the most seasoned, experienced, and highly regarded firms in the Commonwealth of Pennsylvania. The team included 4 major law firms: Rhodes & Simon Authority Counsel, Obermeyer, Redmond, Maxwell & Hipple Bond Counsel, Eckert, Seaman, Sharon & Malott Underwriters Counsel, Meddy, Evans & Woodside County Counsel, 3 financial and swap advisory firms, Milt Lopez Associates representing the authority in the city, Investment Management Advisory Group representing the authority of the city and the county, Public Financial Management representing the county, and 7 other underwriting firms as co-managers for the bond sales. Additionally, both City Council and the County of Dauphin retained separate, independent, major engineering firms expressly for the purpose of reviewing every aspect of the retrofit plan put forth by Barlow and opining on its feasibility, precisely because they knew other professionals were not in a position to offer that advice. The conclusion drawn in the forensic audit that this team of many of Pennsylvania's finest bond professionals somehow misled or forced this financing upon an uninformed authority, city, and county is absurd. In my 30 years in the public finance industry, I have never been involved in a project with more scrutiny from governing bodies than the 2003 retrofit project received. And this wasn't cursory scrutiny. It was scrutiny that honed in on exactly the critical issues: to retrofit or not retrofit, and was Barlow capable or incapable of completing the project on time and on budget. During the summer and fall of 2003, City Council held numerous public meetings where literally hundreds of citizens appeared to hear presentations on the project from the working group. Leading off every meeting were representatives from Barlow who spent the first 30 to 60 minutes reviewing the feasibility of the project, the Barlow technology, Barlow's past experience with other incinerators, and importantly, their projections of revenues and expenses of the retrofitted project. Following Barlow, the other members of the finance team made shorter presentations on the actual financing itself, including legal requirements, the need for financial guarantees from the city and county, the use of bond insurance, and the actual structure of the debt. At the conclusion of the presentations, the floor was open to anyone in the audience with an interest in speaking about the project. These meetings were widely publicized in the press, and many were televised. Right to the evening of the final city council vote in November, there was great uncertainty as to whether the project would be approved. On the night of the final vote, each of the council members made lengthy speeches prior to voting, explaining the deliberative process they had followed in reaching a decision. It is impossible for any objective person to conclude upon review of the meetings, the correspondence, and the bond documentation from that period, that any decision maker in the approval process was not fully aware that the primary risk to the success of the retrofit project was the timely performance of Barlow. This report makes the inaccurate accusation that the financing team was somehow derelict in not thoroughly reviewing and critiquing the Barlow technology, engineering plans, and revenue and expense projections. This criticism fundamentally miscomprehends each party's role in a public finance transaction. It is the role of the engineering firms to address project technology, project feasibility, projections of revenues and expenses. The financial professionals criticized in the report do not have that role. Bond attorneys speak to the complexities of federal, state, and local laws and requirements for municipal bond offerings. Financial advisors and swap advisors speak to the structure of the financing and offer views and opinions on use of financial products and the fairness of pricing. Trustees safeguard bond proceeds. And finally, underwriters like RBC Capital Markets give market information and views on optimal bond structures and then sell those bonds to investors. Another fallacy of the report are the statements that the 2003 financing in some way has not performed well, was too complex, and has subjected the authority and the city to undue risks and inflated costs. The truth is that the swaps utilized in the 2003 financing have performed even better than expected and were not excessive, overpriced, or speculative. Most importantly, the swaps of the Royal Bank of Canada have saved the authority money. With the benefit of nearly 10 years of history, it is now possible to review the performance of the 2003 financings. As the audit correctly points out, the most traditional and conservative financing plan would have involved issuing 30-year fixed-rate bonds. Given market conditions at the time in 2003, short-term rates were extremely low and the yield curve was very steep, meaning that short-term rates were low, long-term rates were high, a steep curve we call that. The September 2003 change in the Pennsylvania Local Government Unit Debt Act that authorized the use of interest rate products by government entities, and the recognition by the financing team that the projections indicated operations at the retrofit facility would be tight, this decision was made to include a significant amount of variable rate debt in the 2003 financing with the goal of lowering interest expense. The decision to include a swap was based simply on the expectation that it would be a better source of variable rate financing. The report's 18-page discussion of the swap transactions is fundamentally wrong in many respects. The financing plan used an interest rate swap to exchange the Series D from a fixed rate of interest to a variable rate of interest for the reasons mentioned earlier, namely to access the low interest rates available in the short-term market in 2003. Pennsylvania bond law requires that any variable rate debt have a maximum stated interest rate, and consequently, the fixed to floating rate swap had a maximum statutory rate of 12% embedded in the swap. This was not a separate swap or two swaps as the report talks about. It was just embedded in the swap under state law. However, while the mayor of Harrisburg was willing to recommend taking variable interest rate risk on a significant portion of the debt, he directed that a more realistic 6% cap be included in the plan of finance to protect the project from significant increase in short-term interest rates. Said another way, while the short-term rates of approximately 1% that prevailed in 2003 were clearly much more attractive than the alternative of 5% fixed-rate bonds, the mayor felt that by allocating some of the benefit expected from the low short-term rates by purchasing a more protective 6% cap would be prudent. So what the report described as 6 different swaps in substance was one swap and one cap pursuant to which the authority received a fixed rate and paid a market-based floating rate capped at 6%. Now, there were 2 series of the Series D bonds. two sub-series of Series D bonds, and we split the swap into two pieces, but it was the same swap. In full compliance with Pennsylvania Act 23, the authority, the city, and the county were all advised by independent financial advisors with specific swap advisory expertise. A detailed interest rate management plan required under the Act was adopted by all three entities. The purpose of the plan is to identify and list various risks associated with interest rate swaps, provide termination analysis, project debt service at maximum interest rates, and detail fees paid to professionals. Act 23 also requires that governmental entities receive updates on the plan at least on an annual basis. Royal Bank of Canada fully disclosed its compensation on the swap transactions to the independent advisors, and those advisors gave clients fairness opinions as required under Act 23 at closing on the financing. The breakdown of the swap spreads contained in the report is grossly overstated and inaccurate. The use of interest rate swaps in the financing structure enabled the authority to benefit from the extraordinary low short-term interest rates that prevailed in 2004 and much of 2005, and provided lower debt service than projected at the time the financing closed in 2003. As the economy improved in 2004 and the Federal Reserve began a tightening program, short-term interest rates began to rise. Conversely, long-term interest rates dropped sharply, leading to what would eventually become an inverted yield curve, where short-term rates are actually higher than long-term rates. This environment proved to be an opportune time for the authority, the city, and the county to consider reducing the risk to variable rate debt as short-term rates were rising. In August 2005, a second interest rate swap was entered into that locked in a fixed rate beginning in June 2006, which was the expected end of the construction period, and extending through 2033, which was the remaining term of the financing. The fixed rate available in the swap market at the time was 3.35% through 2033, which was a historically low rate and approximately equal to what the authority hoped to pay over the life of the financing had they been in the variable rate market. Stated differently, the authority had benefited from short-term rates since December 2003, could continue in the variable rate mode through the expected end of construction in June 2006, and could then convert to a fixed rate that approximated the assumed rate for the entire life of the financing. It represented prudent interest rate management planning, precisely as called for in Act 23. By the spring of 2006, the interest rate cycle had changed again and long-term interest rates had climbed, creating significant market value in favor of the authority tied to the fixed rate swap they had just executed the previous August 2005. Additionally, the project by this time was delayed and struggling. The authority chose to realize the gain available in its 2005 swap by terminating the swap for the years from 2011 to 2033. The termination resulted in a payment of over $4 million from the Royal Bank of Canada to the authority. This enabled the authority to retain a fixed rate during the ramp-up period from 2006 to 2011, when the authority would be least able to weather swings in variable rates, while at the same time obtaining the value created from its actions in 2005. Not only was this a carefully considered and otherwise reasonable strategy in 2006, with the benefit of perfect hindsight, it has proven to be the right course of action. The authority had an immediate gain of $4 million, had fixed rate debt at 3.35 for the important early years of the project, and it is now enjoying interest rates of approximately 0.5%, 50 basis points, on the remaining 65 million Series D swap through December of 2013, when the swap will be gone. Perhaps even more importantly than the interest rate performance of the financing plan, the use of an interest rate swap to create synthetic variable rate debt, as opposed to utilizing traditional variable rate debt with bonds backed by letters of credit and municipal bond insurance, allowed the authority to steer clear of the upheaval that plagued much of the variable rate bond market when the credit crisis erupted in 2008. Had the authority used traditional variable rate debt backed by FSA and a bank letter of credit, and a bank providing a liquidity agreement, its variable rate debt would have spiked to rates of 10% or more, a situation many Pennsylvania issuers experienced in the 2008 and 2009 crisis. The authority's decision to access the variable rate market through an interest rate swap, rather than the traditional manner, has worked to immunize it from all these factors and has delivered low-cost financing. RBC Capital Markets has completed a financial analysis that takes into account all cash flows on the Series D of 2003 bonds and the two associated swaps. The authority's cost of funds to date is 3.35%. Going forward, through the termination of the final interest rate swap in 2013 and using conservative projections through that time, the estimate is that the final cost of funds is likely to be 3.25%. Had the authority chosen a traditional fixed-rate structure, its cost of funds would have resulted in an interest rate of approximately 5.03%, based on the fixed rates available in December 2003, when the bonds were sold. Consequently, the structure that was utilized has saved the authority over $11 million compared to a traditional fixed-rate issue. Even more significant, if a comparison is made of the actual debt service experienced on the Series D bonds to what was projected in the offering circular for the 2003 bonds, which was a projection based on a long-term average of the variable rate index, a savings in excess of $5.2 million has been generated. Clearly, the original financing of the 2003 retrofit project was not a contributing factor to the problems that exist today. By 2006, it became apparent that the retrofit project was struggling and completion would be delayed and over budget. Anticipating the difficulties that would accompany that scenario, RBC Capital Markets informed the administration of the city of the privatization movement that was gaining traction in many public jurisdictions around the U.S. After several meetings, RBC Capital Markets was engaged by the City of Harrisburg and the Harrisburg Parking Authority to evaluate a long-term lease for the parking assets. RBC Capital Markets devoted over 2 years' work, including many hundreds of man-hours and huge expense, and delivered at the end of the process a high bid of $215 million from a fully qualified bidder. The mayor's plan was to close the lease transaction, pay off the parking debt, and use the net remaining proceeds of approximately $100 million to pay down the excess resource recovery debt. After many public meetings over 4 months, City Council rejected the parking proposal in October 2008, a decision which has contributed to the current dire situation. Ironically, one of the key recommendations that came out of the Act 47 plan and also the receiver's plan is just such a transaction. Unfortunately, the value of a parking transaction under current market conditions is less than the value rejected by City Council in 2008, and of course, the delay in implementation has allowed the problem to grow far larger. While we are extremely sympathetic with the situation that the authority, the city, and county currently find themselves in, it is important that we address some of the more egregious errors in the Claire Harrison report with respect to RBC Capital Markets and Royal Bank of Canada. We stand by our work product and believe adamantly the current problems have nothing to do with the financing plan for the 2003 bonds. Sorry about the length.
Well, thank you very much. Senator Fulmer, you have some questions?
Yes, I do, and thank you very much for your testimony, sir. And just bear with me.
Sure.
My first question is, who did RBC represent on the incinerator financings?
We represented the authority.
Okay. How was RBC selected? Would you know?
RBC has had a long history working with the authority on various financings.
Who did you report to? What was your role?
Who did I report to?
Yeah, who did you answer to? I mean, who?
Do you mean
the board?
Oh, do you mean at the issuer?
Yes.
Right. The board of the Harrisburg Authority made the final decisions. We also had meetings for City Council. City Council had to approve things, and also the county had to approve.
Okay. Thank you. Did RBC provide financial advice to the authority on the incinerator finances?
We certainly gave our ideas with regard to how to structure the bonds in the most advantageous way, given our expertise.
Did RBC provide financial advice to the city on the incinerator financings?
Certainly, we would offer the same kind of structuring advice with regard to how to best access the bond market.
Did you? So you did with the city too, right? You just answered that, yes. So was that like a conflict of interest?
No, the city's guarantee was part of the financing, and as part of the any financing plan, the authority would take action. The city was a body that needed to take action. The county, in this particular case, also needed to take action. So we also made presentations to the county.
Okay. In 2003, Barlow did a series of 4 analyses on the incinerator. March 24, 2003, May 13, 2003, November 6, 2003, November 26, 2003. Now, these reports were key to determining if the debt would be self-liquidating, and each report contained debt service information provided by RBC Dane Rauscher, if I'm pronouncing his name correctly. Are these the reports, the ones that Mayor Reed relied upon to certify the incinerator debt was self-liquidating?
I don't know what Mayor Reed relied upon. If you're asking, did we as an underwriter provide debt service schedules to the engineer? Absolutely, yes.
What was your role in generating these important informations?
We have a whole team at RBC, so my role was the primary day-to-day fellow. We also would have analysts, of course, that would generate those numbers.
Did you raise any red flags that the debt would not be self-liquidating?
No.
Okay. Now, page 40 of the forensic audit talks about an email you sent to an individual from T. Rowe Price stating, and I quote from the forensic report, and bear with me here, and I quote, "My only word of advice is if you are trying to evaluate this, i.e. the 2003 financing, on a revenue generating basis, you are the only one including the bond insurer. Bottom line is that there is a AA county with a full faith and credit general obligation pledge." Now, are you saying in that quote, are you saying that the 2003 was primarily based upon the county's guarantee rather than the facilities generating sufficient revenues? And if the incinerator was self-liquidating, why weren't the bonds also marketed based on the revenues of the facility?
Let me elaborate on that, on your question. These bonds were among the most secure bonds in terms of structure of any bond issue that you can imagine in the state of Pennsylvania. First and foremost, they were backed by a rate covenant that said that the authority would charge rates for tipping fees and things like that at the incinerator that would be sufficient to pay operating expenses and pay debt service. First and foremost, that's an important thing for everyone to recognize. Every revenue bond issue done in the state of Pennsylvania will typically have a rate covenant. Actually making that rate covenant, listening to that rate covenant and implementing that rate covenant is key to revenue bonds. If you ignore the rate covenant, then of course revenues are not going to be sufficient. So first and foremost, there was a rate covenant. Secondly, there was a City of Harrisburg guarantee. Third, behind that was the County of Dauphin guarantee. And then finally, there was municipal bond insurance that got the entire financing to a AAA level. So my email to that gentleman was the real credit strength here, because it's our job, remember, as an underwriter, to get the lowest possible interest rate we can get for our clients. So I wanted that investor to focus on the strongest possible credit provider here, which was the County of Dauphin. And in fact, the OS that was used to market the bonds, if you gentlemen have looked at that, is replete with all kinds of disclosures that first and foremost look at this as the ultimate source of payment are the guarantors.
Then that leads me to my question. Did you believe the incinerator bonds to be self-liquidating?
I didn't have a belief. I'm not an engineer. Certainly all the engineers' reports showed that they would be self-liquidating. And again, importantly, had the rate covenant been implemented and followed, it would be self-liquidating.
Okay. Did you personally recommend to the authority or to the county that they use RBC as a counterparty on the swaps?
I recommended that RBC serve as a counterparty, yes.
Was there a conflict in RBC serving as investment banker and as a swap counterparty?
In my opinion, no. Across the country, it is more common than not that the senior managing underwriter is a swap provider, assuming they have a highly rated bank, as we did. We were AA rated bank.
Okay. How much was RBC paid as a counterparty on the swaps? Just a ballpark figure.
RBC, and this was all fully disclosed to the swap advisors at the time, RBC worked for approximately 10 basis points on the swap transactions, not the 20 or 21 that's reported in, or 18 to 21 that's reported in the report, 10 basis points.
Earlier in your testimony, you noted decision makers were fully informed of the financial risks in these financial transactions. If so, why do you believe they moved forward with these transactions?
Oh, I think they moved forward because they had wholesale belief that the facility would be built out and would generate the type of revenue that was projected to do. And as others have testified, the plant is generating actually $5 million more today than it was projected to generate. Of course, it wasn't done on the initial financing. It needed to be follow-on financings to get it to that point. But solely, certainly, as I said in my opening comments, in all these meetings, there was a very conscious decision, retrofit or not retrofit, and the repercussions of that. So they did it because they felt that it was going to work, as we all did on the financing team.
And then going back to swaps, and I know you spoke to it at length in what you just read to us, and maybe I missed this, and I'm going to ask this question. What are your thoughts on swaps in general?
My thoughts on swaps in general, and just as background, Act 23 was passed by the state of Pennsylvania in September of 2003. To date, there have been over 700 swap transactions that have been carried out by local governments within Pennsylvania. My own view is that when used prudently and with the right professionals that know what they're talking about and know the risks and know the profile of their clients, they have a very, very good role and a valuable role. And in fact, when the Pennsylvania Senate convened hearings after the Auditor General's report came out a couple of years ago about the Bethlehem area school district excessive use of swaps, the Pennsylvania Senate held hearings in one of the committees, and they found that many, many issuers around the state of Pennsylvania, governmental issuers, came to that hearing, including the School Board Association and others, talking about how they did not want the swap law changed, that when used prudently, I think they are a very valuable tool.
Did you advise the city on any swap transactions, and how many, if yes?
I was never acted as a swap advisor, no.
Okay. Well, okay, then okay, I'm done. Thank you.
Sure.
Because you
Thank
answered that last question.
Chairman Blake?
Thank you, Mr. Chairman. Thank you, Mr. Losty. I guess Senator Fulmer has addressed, again, some of the issues I was going to raise. You make a rather compelling contrast in argument. I guess my first comment is this. It seems to me that you have made an extraordinarily powerful argument that the interest rate risk that the facility would realize vis-a-vis these swap transactions was probably mastered properly to the market conditions within which it was done. What concerns me deeply is the sheer amount of debt that was incurred, and you've already answered this already, but I just wonder if you can extrapolate again. The representations made in selling the bonds included, for instance, your point about the covenant on rate, all these other factors that were related to the pro forma that the engineers had blessed as demonstrating for you as an underwriter the ability for the performance and the debt service obligations that were to be borne. I'm just trying to get a sense of the dynamic in the selling of the bonds vis-a-vis the guarantees. Without the guarantees, they don't happen, right?
Well, without the guarantee, let's back up for a second. The municipal bond market is a market that is a broad market, but the vast majority of it, 90% of the market or something like that, is what we call the high-grade municipal bond market, which basically is anything in the investment grade rating, something in the BBB, all the way up to AAA rating. And the reason for that is municipal bond investors receive a very low interest rate on those bonds. In today's market, it's the lowest in history. It's 2%. In 2003, it was 5%. Investors getting 2% today or 5% in 2003 are not interested in taking undue risk. They look at municipal bonds as an extremely safe investment, and because of that, they're willing to take a very, very low interest rate, and these are for 20 and 30-year bonds. So to get 2% today or 5% in 2003 is a very low rate. So the market itself, 90% of the market is that very high-grade investment grade market. There is a small percentage, 10% or so, which we would call the non-rated market or the speculative market, tends to be used for nursing homes and retirement communities and things that can't qualify for a strong rating on their own. Those bonds carry a much higher interest rate than the investment grade market. And in the case of Harrisburg, because there was significant debt on Harrisburg, I was very frank with the mayor in the summer of 2003 and saying, we can't go any further. The earlier deal we did that restructured the debt was that the market was saturated with just Harrisburg debt alone in terms of the city guarantee. The only possibility was if Dauphin County, in spirit of cooperation, would agree to step in and back the bonds, that there would be a viable financing alternative. Other than that, the bonds were not saleable.
Understood. The other thing, I guess, you've already made an argument that the swap decisions that were made were the proper ones. Variable rate debt for the next 30 years, and those costs. You've made a compelling argument in your opening testimony that, in fact, the decisions that were made about these transactions have made the circumstance for the incinerator financing less difficult than it otherwise could have been. Is that your?
That's correct. It's the 2003 financing has achieved a rate of 3.25% by the end of 2013, and actually, given what it appears that the authority will be selling the incinerator at some point here. It's actually coincides perfectly because the debt will all come up for the most part to be able to be retired at the end of 2013. And if it's not retired, if for some reason the city and county and authority decide to stay in this debt, the market has completely bailed them out to some extent. We're at the all-time low interest rates. We could turn around and refinance these bonds for the next 20 years at 2.5% today. So the market, and again, it wasn't that we had a crystal ball, but it turns out that the 03 financing has worked better than ever expected.
Understood. Your only fiduciary responsibility is the underwriter, RBC. You didn't, according to your responses to Senator Fulmer, you didn't advise particularly the mayor or the authority. You just simply did the underwriting.
We did the underwriting, but
perspective.
to be clear, no, we did not serve as financial advisor, but the role of an underwriter is to present ideas and give thoughts so by no means do I want to leave the impression that I didn't offer advice at times in terms of what I thought were good financing decisions, but the authority engaged an entire team of financial advisors who ultimately would make the final advice. But certainly I'm not someone that is shy from giving my opinion, so I would give my opinions.
Understood. The only other point I have here right now, Mr. Losty, and I appreciate it's just really a technical clarification I'm looking for. There was a Barlow pro forma included in the closing for the 2003 DEF bonds. Page 7 of the data on that. It's an exhibit that lists, I guess, all of the sources and uses, and conspicuously omitted in the sources and uses is the city guarantee fee. And if you can't answer that for me now, it'd be something I'd like clarification on after this hearing, if possible. It has to do with the issue in 2003. It would be the $125 million. It lists total issue sources and uses, and does not indicate the $4.2 million guarantee fee to the city. And that's just something.
Okay, yeah, we can get back to you on that because I know many of the numbers do show the 4.2 million. You're correct. I don't see it on here, but I don't know the answer for that offhand.
Okay. And thank you for your testimony.
Sure,
Mr.
thank you.
Chairman.
So, Mr. Losty, the swaps were your proposals?
The swaps were our proposal, yes, sir.
That answers the question we asked Mr. Barnes a little while ago. Now, you consider yourself to be part of the finance team that was put together here?
Yes, sir.
But your client was the authority.
The bonds were issued by the authority, so ultimately but the signatory on the bond purchase agreement was the city, county, and authority. So all three were involved, obviously.
Okay, now this is where this kind of blurs for me, if you can explain this a little bit better. With your involvement over that period of time, the development of the self-liquidation statement, you didn't have any role in that then?
No, as I think I mentioned earlier, our role in the self-liquidating debt report was to provide the debt service projections. What did the $125 million in bonds, what kind of debt service was going to result from that 125? We provided that to the engineer to include in his report, and that was basically a market-based thing. What could we sell the bonds for?
So you understood the cash flow difficulties of the project?
Oh, I think everyone, as I said in my opening statements, everyone involved in the project knew that cash flows, once it was built out, would be tight.
Yeah. Well, I had mentioned a little while ago about some of these foundational issues about how tight that was. I mean, it was unrealistically tight as far as the Barlow report went for the construction schedule. And
and I would disagree that the revenues that the facility is generating today exceed what was projected in the Barlow report. So in 2003, the debt that we were involved with, the debt service that resulted from that bond issue compared to the revenues that exist today, the plant would be fine had it not been for the fact that that was not enough debt, as we know with this, and the CIT and the 2007 financings then were necessary to complete the project. But in 03, the debt and the revenues matched.
well, as I recall that revenue projection, that didn't have anything to do with what they're getting today. The numbers they're getting today, the places they're getting the refuse from is entirely different than what was projected.
I'm not sure I understand your point.
The fees are much higher today than the projections were then.
Tipping fees are higher than they are today, yes.
Much higher.
And again, I go back to the rate covenant. The authority had a rate covenant, and if the tipping fees were even higher today, there wouldn't be a problem. There would be, the facility would be generating even more revenue and carrying all its debt.
But we can't, in fairness, compare what the projections were to reality today, because they're two different financial situations. I mean, we could charge fees today for anything, name a number and put that in as a fee schedule, and that would change what they're getting.
Or we recognize that's what a rate covenant is. It specifically says, year by year, set rates to generate revenues sufficient to pay your operating expenses and pay your debt service. That's why, and this isn't new finance. And throughout the Pennsylvania for 100 years, water projects, sewer projects, parking projects, convention centers have utilized this form of financing with rate covenants.
But it didn't unfold that way.
Again, the problem, if you go back and look at what happened today, is that the project could not be completed for the 2003 financing. It required follow-on financings, which increased the debt load with higher debt service, and that caused the whole equation to get out of balance.
When did you? I assume you were aware at some point that the project didn't have the contractor didn't have a performance bond.
No, when the financing closed in 2003, as I think others have testified, and you may hear from others today, the actual construction contracts and all were not complete. They weren't completed until May of 2004. This was what we call an advance funding, a funding in advance of all the final contracts being let. So, and additionally, as part of the bonding documents in our bond purchase agreement, there was a certification by the city, authority, and county, or by the authority anyway, I don't have it in front of me, that said that certifying to RBC that all necessary performance bonds to qualify under state law would be included by the time the contracts were let. But we sold the bonds in December, and this whole issue of the finalization of that performance package was not until 4 or 5 months later.
Okay, so who certified that then?
And I don't have the BPA in front of me, but we can check that. I think it's the authority.
You don't know who specifically was involved in that? What professional? Who? Was it one person? Was it a group of people?
I don't. But the lawyers coming on after me could better address that than I could.
Yeah, that's fair enough. I had asked a question earlier about bond indentures being changed over a period of time so they're less restrictive. Do you know anything about that?
I heard your question earlier, and I don't have a recollection on that. Again, I think the bond attorneys coming on could talk because they tend to draft the bond documents, the actual indentures themselves.
With your payment agreement, would you have been paid if these bonds did not go through?
No. Typically, that's how underwriting works. If there's a bond issue, there's a payment. If there isn't, there is no payment.
In 2006, as I understand it, you were, there was a swap that was terminated. I think that's what you'd mentioned earlier in your prepared remarks. Was that the one where it was $4 million generated?
Yes, just to reiterate, in 2005, when interest rates were starting to change because the economy was heating up and the Federal Reserve started to raise short-term interest rates, instead of that steep yield curve that I talked about that existed in 2003, we were getting to a flatter curve where short-term rates were going up, long-term rates were coming down. At that point, we could lock in a swap rate for the remaining 27 years of the financing at that point at 3.35%. And it was my thought is, going back to the projections we made in 2003, we hoped by staying in variable rate bonds for the whole life of the issue to achieve approximately 3.25%. So if we could lock in at 3.35% and take all the risk off the table in 2005, that was a prudent thing to do. And so we entered into the swap in 2005, and then what you're referring to in 2006, as the project was struggling and rates had shot back up, long-term rates had gone up, the authority suddenly had the opportunity to realize a $4 million gain from basically terminating the back end of their swap, still keeping the 3.35 in place through 2011, but taking off the swap from 2011 to 2033.
I couldn't find anywhere where the city or the county authorized that change. Do you recall how that was done, how you were authorized to do it?
There's all kinds of documentation on it, and always official action was taken, so official action would have been taken, but you can maybe ask some of the attorneys who are coming later, but we can't enter into swaps or terminate swaps without official action being taken.
Okay. The one thing that was curious to me, and I think it was part of the 2003 agreement that you had spoken about, you were protecting against a 12% interest rate. Was that a prudent move at the time? I mean, 12% to me seemed like it was a very high interest rate to protect against.
Recognize what I said. Under state law, for every issuer in Pennsylvania, if you issue variable rate bonds, you have to have, under state law, a statutorily mandatory interest rate. And the statutory mandatory rate that was built in this document was 12%. That was not a separate swap. That was not anything that cost the authority money. That was just embedded in the swap at 12%. It was what we would call a cost-free cap, and that's to qualify for state law purposes. And then to finish, as I mentioned, the mayor felt that 12% was too high a rate, that not that anyone thought that rates were going to go to 12%, but that he wanted a more realistic cap. So that's when the cap decision was made to drop the cap to 6%.
You know, getting back, one last one for me, I don't know if anybody else has anything or not. Yeah, I think we'll have a couple follow-ups, but on this performance bond situation. So once that happened, and that was after the fact, did that affect anything that you were doing, or was there an obligation of some kind to inform investors, or how did that work?
No, the bonds had been sold on a fixed rate basis. Certifications were made. Others have, Dan Losty, I know at the last hearing talked about that he thought that the performance package did comply with state law. Others today can talk about it. So it did not result in any upheaval in the market. If that's for the authorities' bonds, if that's the question.
And you're convinced that investors were fully informed about the financial strength of the project itself, and relying more on the guarantees of the city and the county?
I don't understand your question. That they were fully informed on the financial strength, or what do you mean?
Of the project, that the project couldn't pay for itself.
Oh, I think if you look at the OS, there's no discussion in there about evaluate this on the projections of revenues and expenses. It's complete. The strength here are the guarantors. We expect the revenues will be there and the rate covenant will be followed, but the strength is the guarantors.
What shape was the city in at that point, though?
Well, as I mentioned earlier, had the county not gotten involved, the city could not have borrowed an additional $125 million on their own credit strength.
But the investors, you think that there was enough disclosure that the investors knew that the city also probably couldn't pay these bills?
Absolutely. If you, again, that OS is like a New York phone book.
I'll confess, I did not read that entire OS.
All you have to do is read the first few pages where all that is disclosed up front.
Chairman Blake.
Thank you, Mr. Chairman. Mr. Losty, thank you. I just have one more point of clarity I want to get, because you've described this. I'm just trying to. A lot of what I've done in the first and second hearing here is try to understand what we might have to do legislatively, if anything, to deal with this circumstance, and whether or not there's any statutory or regulatory flaws or weaknesses in the process of municipal finance and authority financing. You mentioned that there's a representation made to the investors with respect to the project satisfying all statutory requirements for performance bonding. So that's the first representation that's made, and then you have this being funded prior to the conclusion of construction documents and the execution of the project vis-a-vis those construction documents. That's right?
That's correct. Yes, sir.
Is that, by the way, is that a frequent?
Very frequent. School districts, for instance, around the Commonwealth, commonly, when interest rates look good and they have a project down the road, they do what's known as an advanced funding and borrow money today and put it aside for 6 months or a year and wait for the project to be crystallized.
Understood. So then there was a later judgment being made by those that had the authority to make the judgment that a performance bond that would otherwise be statutorily required could not be obtained. But they made representation of an alternative security, and there is some legal opinion somewhere that says to the authority or to the city or both that what has been suggested as an alternative satisfies state law with respect to that security. Is that your...
That's my understanding, yes,
That's your
sir.
understanding? So in that interpretation, then there's nothing that need be restated to the investors. There's a sense of the similar security being given. Is that
Correct. Yes.
correct?
Yes, sir.
Okay, thank you.
Earlier today, and actually it was right before, excuse me, right before lunch, our lunch break, Mr. Bruce Barnes noted that 6 swaps in 2 years is highly unusual, he said. How do you respond to that?
Well, I think Mr. Barnes was in error that there were not 6 swaps. As I went through in this long diatribe I started off with, there was 1 swap done at the time of the 2003 financing. It was divided into 2 pieces because the 03 bonds had a 5-year and a 10-year maturity. So it was documented as 2 swaps, but it was 1 swap, and then there was 1 COT associated with that. So I don't have any further comment on what Mr. Barnes said.
If there was only 1, then how many times was RBC paid?
RBC was paid at the time we executed the 2003 swap and cap. There was sometime in the summer of 2004, the cap was changed from a SIFMA cap to a LIBOR cap, and we made a fee at that time. And then when rates turned down, and in 2005, when we entered into the second swap, there was a fee at that time, sir.
So basically you applied 3 times for 1 swap then?
No, not 1 swap. Totally different swaps. 1 time for 1 swap.
Well, you said there was only 1 swap.
There was 1 swap in 03. There was a second swap in 05.
Okay. Of all the swaps you have been involved in, how complex or unique would you rate the Harrisburg swaps?
Not complex or unique at all. They were at this time, and I remember in September of 2003, the state of Pennsylvania had passed the changes to allow swaps to go forth, and there were many issuers around the state of Pennsylvania and around the country, quite honestly, that were utilizing interest rate swaps to create, in this particular case, variable rate financing, but also, as Mr. Barnes talked about, create fixed rate financing. So these are very plain vanilla swaps.
Several testifiers have talked about the role of engineers. Who were the engineers and what did they do?
Well, I think the engineers are certainly there on the record. It was Barlow as an engineering firm, and then the county and the city council each hired their own engineering firms, Buchard Horn and HRG, I think was the other firm. And their role specifically, because everyone knew the primary risk here was Barlow capable, and could Barlow deliver, would the technology work? There was great doubt on the part of city council, and even the county wanted it validated. So their role was to come in, evaluate the technology, evaluate the capability of the firms, and also look at the projections of revenues and expenses and see whether they were...
If that's the case, then why weren't there any red flags being thrown up if they were that concerned?
And again, I think that you have not had engineers come in and talk to you, but that would be a question for them and not for me.
And then finally, I just have this question because you're a financial advisor with RBC and such. Why do financial advisors place so much reliance on the financial advice of engineers? Why won't the financial experts generate their own financial projections?
Well, and again, to clarify, I'm a municipal bond underwriter, not a financial advisor.
I'm sorry.
So it's the underwriting firms. It's never our role. As I put in my opening statements, every party, the reliance of everybody involved in a financing team is that each individual party is competent, experienced, and capable of performing their job and their role. For us to try to suggest that the engineering design was faulty or that their revenues are this is a complicated project. It's a cogeneration plant for an underwriting firm or a bond lawyer or a trustee or an FA to walk across the line. That's where you get into trouble when you start going beyond your areas of expertise.
Then, okay, then what you just said then that brings up one final question from me. Is that whether RBC or whoever the financial advisors were and so forth going forward, how could you get the best fiduciary advice when you weren't sure that the engineering or the project was actually going to work?
because we relied in fact, if it were only Barlow, that would even be a more apt question. But the fact that you had Buchart and HRG that came in and said that this looks reasonable, it looks viable. I mean, why? So we had 3 engineering reports that said it would work.
Okay. Thank you, sir.
Sure.
Okay, thank you.
Okay.
Thank you, Mr. Losty. We
Thank you.
appreciate your time today.
Thank you.